Good afternoon. My name is Ubaid Dero and my University of Hertfordshire ID number is 240592990. Today I will be advising Sulayman, the owner of Haveili House, a restaurant situated in Hatfield, about his rights and remedies under the Sale of Goods Act 1979. This concerns a recent purchase he made from Amjad Furniture House store in London, which included marble tables, velvet chairs, and a leather sofa. The issue arises because the items delivered did not match what was promised at the time of sale. As this was a commercial transaction between a business owner and a furniture retailer, the relevant law here is the Sale of Goods Act 1979. This act governs the implied terms, delivery, obligations, acceptance rules, and remedies available when goods are defective or they fail to meet contractual expectations. Number 1. The contract of sale. A contract of sale of goods exists when a seller agrees to transfer ownership of goods to a buyer in return for a monetary price. Here, ownership or property in legal terms is key, not just physical possession. Suleiman purchased specific goods like tables, chairs, and a sofa, which fall under Section 61, subsection 1 of the Sale of Goods Act 1979. This section confirms that existing specific goods are considered goods under the Act, and the rule for passing the property help determine who bears the risk if the goods are defective. In this case, because Suleiman purchased these items for his restaurant, ownership of the goods was intended to transfer to him, and the obligation of the seller under the contract were therefore strict and enforceable. Number 2. Implied terms relevant to the case. Several implied terms of the Sale of Goods Act are central here, like Section 13, which states goods must correspond with their description. Further on, Section 14, subsection 2, which says goods must be of satisfactory quality, meeting the reasonable standards expected for the type and the price. Further on, Section 14, subsection 3, which says goods must be fit for any particular purpose made known to the seller. And Sections 27 till 30 says duties regarding delivery and the correct quantity of goods. Section 15A limits the buyer's right to reject only in cases of minor or trivial breaches. Section 35 defines acceptance of goods and how it affects remedies. Section 53 allows recovery of damages caused by a breach of contract. Now let's examine each item of furniture and see which of these terms have been breached and what remedies Suleiman can pursue. Now let's discuss marble tables that Suleiman bought. Suleiman ordered 25 extra large grey marble tables to match his restaurant refurbishment. However, the delivery was wholly unsatisfactory. 10 medium marble tables, 9 wooden tables, and only one extra large grey marble table was delivered to him. This constitutes a major breach. A. Section 13. Goods must match the description. Section 13 establishes that goods sold by description must match that description. Previous cases such as Rimur and Co. and Arcos versus Ronison show that even minor deviations can breach this provision. In Suleiman's situation, the differences are not minor. The size, the material, and color of the tables were wrong. This is a clear violation. B. Section 30. Wrong quantity. Section 30 allows the buyer to reject the entire delivery if fewer goods are delivered than contracted or if a mixture of correct and incorrect goods is supplied. Suleiman received only one correct table out of 25 that he purchased. This breach is substantial, not trivial at all. So Section 15A, which limits rejection rights for minor breaches, does not apply. C. Remedies for the tables. Now let's discuss them. Suleiman may reject all the tables and is under no obligation to pay. He can also claim damages for additional costs or delays caused, such as purchasing replacements, or postponing his restaurant refurbishment. The law recognizes that when goods cannot serve their intended purpose, the buyer is entitled to a full rejection. Now let's discuss the velvet chairs Sulayman tried to buy. Sulayman purchased 100 velvet dining chairs which were sold as display items at a discount. He was informed that minor wear was acceptable. Upon opening the box, he discovered grease marks and scuffs beyond what was disclosed. A. Section 14 subsection 2 Satisfactory quality. Goods must meet a standard a reasonable person would consider satisfactory. Here, the visible damage was more than minor wear and exceeded what a reasonable buyer would expect. Breaching Section 14 subsection 2. The case of Rogers versus Parrish supports this principle, showing that even small defects can breach the standard if they fall below reasonable expectations. B. Section 35 Acceptance. Acceptance occurs when a buyer either keeps goods without objection or retains them for an unreasonable time. Sulayman inspected only one box, found defects immediately, and informed the seller. Therefore, he has not accepted the chairs. The reasoning is consistent with Bernstein versus Pemson Motors 1987, which highlights the need for a reasonable opportunity to examine goods before the acceptance. C. Remedies for the chairs. Now let's discuss them. Sulayman can reject all chairs or only those that are defective. He may also request a price reduction to claim damages for cleaning, repair, or replacement. Since acceptance has not occurred, all remedies remain available. Now let's discuss the leather sofa that Sulayman bought. Sulayman specifically asked whether the sofa's leather would irritate someone's skin, which is especially a sensitive skin. The sales advisor assured him it would not. After delivery, his daughter developed a red, itchy rash demonstrating a reaction to the material of the sofa. A. Section 14 subsection 3 Fitness for particular purpose. Section 14 subsection 3 applies when the buyer communicates a specific purpose, relies on the seller's expertise, and the seller acts in the course of business. All conditions were satisfied here. The case of Grant versus Australian Knitting Mills shows that reliance on the seller's skill creates liability if goods are unfit for their intended purpose. B. Section 14 subsection 2 Satisfactory quality. Causing a physical reaction renders the sofa unsatisfactory, hence breaching section 14 subsection 2 as well. C. Now let's discuss the remedies for the sofa. Sulayman can reject the sofa entirely, refuse payment, and claim damages for medical costs or inconvenience caused by the allergic reaction. 6. Now, seller's claim too late to cancel. The seller's claim that it is too late to cancel is incorrect. Sulayman has not accepted the goods. Section 35 allows rejection if goods have defects and the buyer has notified the seller promptly. Cases such as versus Clegg versus Anderson confirm that the right to reject remains even if some time has passed, provided acceptance has not occurred. 7. Damages. Section 53. Beyond rejecting the goods, Sulayman may also claim damages, which include direct financial losses, additional costs incurred, and foreseeable knock-on losses. This could include replacement costs, delays in renovations, loss of business revenue, or medical costs from the sofa. The purpose of damages is to restore Sulayman to the position he would have been in if the contract had been properly performed. To summarize, tables breached sections 13 and 30, wrong description and quantity. Chairs breached Section 14 subsection 2 unsatisfactory quality and Section 35 not accepted. SOFA breached sections 14 subsection 2 and 14 subsection 3 unsatisfactory quality and unfit for the purpose. These breaches are substantial, so section 15A does not limit Sulayman's rights. He is not entitled to reject all items, refuse payment, require the seller to collect the goods, and claim damages under Section 53. To protect his position, Sulayman should put his rejection in writing, keep evidence of the defects, and avoid further use of the goods. If the seller does not cooperate, Sulayman may pursue legal action to recover his losses. Thank you for your attention to this matter. That is all for now.